Buenas Danhafade, and welcome to your Guam Congress building. This hearing by the Committee on Innovation, Economic, Workforce, and Youth Development is now called to order. It is 1:03 a.m. For the record, and in accordance with 5 GCA Chapter 8, Section 8107, public hearing notices were sent on Tuesday, August 14th, 2018, adhering to the 5 days notice, and a second public notice on Friday, August 17th, 2018, 48 hours prior. In addition, this hearing was noticed on the legislature's website, www.guamlegislature.com. Written testimonies may be submitted by emailing Senator Biscoe at guamlegislature.org, or you may hand deliver them to our office at 163 Chalan Santo Papa in Hagåtña. Joining me here this morning, to my left, Vice Speaker Therese Terlahi, to her left, Senator Will Castro, and to my right, Senator Mary Camacho Torres. Thank you, colleagues, for joining me this morning. And on our agenda, ladies and gentlemen, for this morning, we have Bill number 322-34, 328-34, and 276-34. We'll begin with Bill number 322-34, which is an act to add a new subsection C to subsection 31.30 of Chapter 30, Title 9, and a new Article 5 to Chapter 13, Title 19, both of Guam Code Annotated, relative to establishing a defense to prosecution for child abandonment, protecting newborn infants from harm by providing a safe and anonymous means for mothers in distress to relinquish the baby to medical professionals, to be known as the Newborn Infant Safe Haven Act. And at this time, I'd like to offer the bill's sponsor, Senator Mary Camacho Torres, to give her opening remarks. And I'd also like to welcome our speaker, BJ Cruz, who's joined us this morning. Senator Torres?
Sedus Masi, Madam Chairwoman. The legislature in Guam finds that Guam has experienced an increase in the abandonment of newborn infants under unsafe circumstances, and that it is in the best interest of the community to protect newborns from such circumstances. Bill 322-34 has essentially 5 major components to the general policy, and that is that the biological mother of a newborn infant may relinquish custody of the newborn infant to an authorized safe haven by voluntarily surrendering the infant to the safe haven personnel, provided that the infant is 30 days or younger, that the mother expresses no clear intention to return for the newborn infant, and that the infant presents no evidence of child abuse that occurred prior to the act of relinquishment. This bill also, under the general provisions, provides for anonymity of the mother, that she may remain anonymous, and that in the event that the mother's identity is known to personnel, that she is entitled to confidentiality. The Newborn Safe Haven Act is essentially a no shame, no blame, no name legislation intended to protect newborn infants that might otherwise undergo harm immediately after birth or within 30 days of their birth. Sidus Masi.
Thank you very much, Senator. And at this time, I'd like to call the first panel of individuals who have signed up to testify. Please come forward and be seated when your name is called. Mr. Sedfri Linsongin, Kevin Riley, Daniel Taitsino, and Carol Hinkle Sanchez. And Mr. Linsongin, we'll start with you when you're ready.
Thank you, Madam Chairman. First of all, good morning to all of you, Vice Speaker, Senator Torres, Speaker Cruz, Senator Castro, and I would like to thank the good Senator Torres for introducing this bill, because in her opinion, this will benefit the majority of the people of Guam. However, I would like to provide my dissenting opinion. Before you support this bill, let us scrutinize the data, the statistics. I don't see any data from the bill that specify the number of abandonment for the last 20 years. What I can only state is that from the newspaper that I read, in the last 20 years, the supervisor from the Child Protective Services indicated that there are only 3 abandoned babies for the last 20 years. That's why there's no alarming situation or increase in number that we have to support this bill. Second, is this for the benefit of the majority of the teenagers and the women in Guam? I don't think so, because there are unintended harmful consequences creating new problem while trying to solve an existing one. With this bill, you will wake up the giant. Do not wake up the giant. They will have an option now. You know, the teenagers and the woman, to encourage them to just have a pregnancy and then, you know, give their child. And also, talking about the majority, then we will not be solving the problem that already exists. Instead of addressing the reason why these 3 people these 3 women abandoned their children, we are not addressing the problem. Instead, we are condoning it, tolerating their action. That's why I don't support this bill. And in 1999, Texas was the first state that enacted this safe haven bill. And after that, in the last 2 years, they did not eliminate the woman abandoning their children. In fact, there's an increase. There's only 33. There are 33 women that still abandon their children, and only 23 that was delivered to safe haven. And also in this bill, one of your intention is to the criminal liability that a woman will face. And I believe we can enact legislation to address that, to lessen that criminal liability, instead of giving the woman a heavy penalty, maybe something else. And then in your general policy, you only have, the woman have only 48 hours to request return of their child if they wish to get their child back. In other states like California, they have 2 weeks to get back their child. And what they did is they put an ID code bracelet on the ankle of the infant, and also give one to the mother. So in case they would like to get it back, then they have the all the information. Now, let me tell you a story about some women that have been into a safe haven program. And what they said is that a man who was abandoned in trash can as an infant declared that this safe haven devalue human life and condemn the child to a lifetime of not knowing about herself. One 40-year-old who was abandoned as a baby lives in a ditch where she was left and says, "I suffered all these years with no identity. I am an offspring of nobody." In Colorado, that was enacted in 2000, 8 babies were still illegally abandoned, and only 2 were dropped to safe haven. In California, there were 19 to 20 illegally abandoned, and 36 babies were delivered to safe haven. In Florida, 11 babies legally abandoned and 14 illegally abandoned. This just dignify that the program is not working and creating another problem. That's why I don't support this bill. Yeah, it's unfair sometimes that people like me will come here and oppose somebody's bill, but when we support your bill, we don't show up. You know, we might oppose 2 or 3 of your bill, but you won't be judged, or I won't judge you with just 1 or 2 bills that we don't support. And your overall performance will be the key. That's what I meant. Because that's what we've been doing. We come here, we almost, all of us mostly oppose, but when we support your bill, we don't show up. So I hope this will require more study, honorable senators. Thank you very much.
Thank you, Mr. Lansang. And now we'll have the spokesperson for the Guam Fire Department, Kevin Riley.
So good morning, Senators, Mr. Speaker. Thanks for having us. I got written testimony that I turned in. Hafaday, with the Fire Chief's endorsement as the GFD Program Manager for the Department's role in this Newborn Safe Haven Act, I'm here to provide testimony in favor of Bill 322, TAC 34, relative to the establishment of the Newborn Safe Haven Act introduced by Senator Mary Camacho Torres. The Guam Fire Department is in full support of this bill with the belief that newborn lives will be saved by encouraging parents to surrender infants safely, providing an alternative to abortion, infanticide, or child abandonment. Since 2015, the Guam Fire Department has been proactive in this effort, exploring similar programs that exist stateside, such as the Safe Surrender Act or Baby Moses Law, that mirror the intent of this bill presented. Recently, Senator Torres reached out to the department to help bring this project to fruition and establish guidelines and training for accountability. The Guam Fire Department ensures its willingness to accept the responsibilities as mandated in Bill 322 TAC 34 should it become law. The Guam Fire Department also remains devoted in keeping with our mission statement that fire stations will be the cornerstone of each community and safe havens for the sick and injured. Thank you.
Thank you very much. From the Office of the Attorney General, Ms. Carol Sanchez.
Buenas, everybody. Good morning, Speaker Cruz, Vice Speaker Terlahi, Senator Castro, Chairwoman of this committee, Senator Lee, Senator Torres, and Senator Muñoz. My name is Carol Hinkle Sanchez. I'm the Deputy Attorney General for the Family Division at the Office of the Attorney General. I apologize, I do have a cold. And I'm here to testify in support of the bill. Back in 2012, our office was in support of the bill when Speaker Cruz at the time had tried to initiate this type of legislation. Although it didn't make it, we're here again to say that our office will continue to support the bill. I just wanted to kind of give you a little history about this actual legislation. So this legislation didn't emerge. The U.S. started seeing a large number of endangerment, child endangerment cases in the late 90s. And prior to Texas implementing what they call their Baby Moses, which is their safe haven legislation, 2 states in like 1981, which was New York, initiated something similar to it, and Alabama was the next state. In 1999 was the actual beginning of safe haven legislation, and from there, and currently, all 50 states, including Puerto Rico, have a safe haven legislation of some form. They're not consistently the same, but there are key provisions that are required, which this current legislation and the prior legislation have included. And so that's pretty much the history of that. So we have 50 states that have it in Puerto Rico. Currently, the only places that don't have it is America Samoa, Guam, CNMI, and Virgin Islands. This isn't just an issue that happens in the United States. You see other countries experiencing the same type of child endangerment. In fact, several countries have implemented some form of safe haven, which they call an anonymous drop-off program, which is like Germany, Hungary, and I believe also South Africa. So it isn't something that is new. It isn't something that is meant to open a floodgate. It's really a preventive measure to protect our children, to protect newborns who can't protect themselves. That really is the key to this type of legislation. Is we're not looking at protecting the parent, although it does provide that protection. The key to this, the focus to this, and the primary job of this legislation is to ensure that these newborns there's an alternative, a legal alternative that parents or mothers can take that would afford this newborn to be placed in the hands of somebody who can safely take them and provide and hand them over to the proper agency, which is CPS. And I have Linda Rodriguez next to me. The intent of the law is also to provide, as you heard the earlier speaker, is also to provide a shield from criminal liability for abandonment. And although it is meant to do that, it's not going to happen in every case. There are exceptions to the law. You can't give a child who's been abused or neglected in that 30-day period and expect the safe haven law to protect you. The child has to be handed over in a condition where there isn't any form of abuse or neglect to that kid. If there is, then the law is not, the possibility of the law not protecting you is there. It's not going to shield you 100%. And that's not the intent of the law, so I just wanted to make that clear. It also provides them an avenue. It provides us an avenue in court to handle these matters in a bit of a quicker fashion. You know, when you have a parent who, in any case, if you had a parent who came today and wanted to relinquish their rights or say, I want to put my child up for adoption, the process will take some time. It goes through, you know, we have issues where we have to ensure there's consent of termination of parental rights. This affords us an avenue so that we can take these cases to court and handle it in a quicker fashion so that we can give this kid a safe, nurturing environment, a stable home. That's so it really goes to the intent of our Child Protective Act. Just because he brought up statistics, I wanted to say that I mentioned 50 states have adopted this, including Puerto Rico, and I also talked about certain factors being included. One of the main things is, of course, the age. You have many different states that have included legislation. Like I said, it's not consistent, but for the majority, most of them have chosen about 30 days. Some of them are even shorter. So that's something that Guam decided, and I think it's a conservative approach. 30 days is a good amount of time. But you have 11 states, including Puerto Rico, that only have 72 hours. Okay, 72 hours, 72-hour old or younger. So 19 states, which is what Guam is doing, has the 30-day rule. Any child can be relinquished in a 30-day period of time. 30 days or older. And again, it's based on the professional's judgment that the child is actually 30 days or 30 days or younger. Because again, we're not going to know, you know, these parents may have given birth at home and oftentimes that's what's happening. That's what was going on in the US. They were giving birth in bathrooms and hotels and somewhere and leaving them in trash cans. And this is what we're trying to prevent. Then you have other states who have increased it between 7 days, 10 days, 14 days, 21 days, but that's like 1 or 2 states. So the majority have followed the 72 days old or younger or 30 days or younger. So we're kind of with the majority of the states in that case. One of the next key provisions is, you know, who can drop the child, right? There are different forms. Guam's legislation chose chose to say that the mother can drop the child, relinquish the child to a safe haven provider. Most of the states allow either parent to surrender, but in this case, oftentimes we have mothers who don't identify the fathers for whatever reasons. The cases we've seen it is where, you know, we have parents who are committing crimes like doing drugs that don't want to identify the father. So the mother generally is the one that's going to have that kid. So that's, you know, that's most of the states allow for either parent, but 4 states in Puerto Rico only allow for the mom. And then we have Idaho, who allows for both custodial parents. And then there are some states who allow an agent. So we kind of tailored, there was kind of a provision. I was able to work with Senator Torres and look at it. So they included a provision that allowed for a safe haven facilitator to be either law enforcement or CPS. So that's one of the other provisions, and it is included. So I kind of went through each of the provisions. And then defining a safe haven provider. Of course, the intent, and when I spoke with Senator Torres, the intent was to ensure that the child was placed into the hands of people who were capable of providing the necessary medical care if needed at that time. Because again, oftentimes they're given, if they do give birth outside of a facility, that baby was probably somebody was the one that was doing the labor of the baby that is not a medical professional, so they would need some type of care, and it would be appropriate for like either the fire department or emergency medical personnel or healthcare facility. And 16 states utilize that same provision. 27 of the other, most of the states actually utilize that, but others have incorporated other agencies, including churches, but it's very minimal. So I think, you know, we follow the practices that many jurisdictions have done. And then the responsibilities of the safe haven, what they are supposed to do, it falls right back to the Child Protective Act. As soon as they obtain protective custody over this child, the child is given to CPS, which is the normal course of our current CPS legislation. So this legislation pretty much mirrors our Child Protective Act in some sense, but it provides that extra avenue for parents who want to give up their child the right way, to have this safe alternative for them that gives them that gives them that protection. Because we have parents who do it, you know, although I don't have the statistics offhand, you know, there are parents who have given birth at the hospital and who have pretty much said, you know, I'd like to give my child up. You know, they know that, so they've done the right course. We didn't have this law in place, but it would have fallen under the safe haven law. But it fell right into the CPS statute, so we were utilizing that statute and the mechanisms in our CPS law to handle these types of cases. And of course, you know, 2 of the other areas is the immunity from liability, ensuring that the providers, the safe haven providers, are given immunity when they do receive this child, which is the same as CPS. If you were to give a child the GPD or CPS under our current Child Protective Act, they're immune from any type of civil or criminal liability when the child's in their care, unless you can prove there was some form of negligence happening to that child while in their care. And then there are other things like consequences of the relinquishment. You know, he spoke about a parent being able to, after they surrender, get back the child. We actually followed the majority. A lot of it is, you know, within a certain amount, a few days of a time period. I mean, it's for the protection of the child. You know, we don't want to develop practices where we allow them to just come back in and take the child, where we know that they don't want the child. You know, these are stress factors. To put a child into a home where there are stressors, where a parent makes it clear they don't want the child, is going to cause problems. We're going to subject this kid possibly to more harm. And so, you know, that's the importance of those provisions. But I basically wanted to give you that history to just identify that, you know, we're not standing alone on this issue. 50 states have it, Puerto Rico, countries have it. It's really for the protection of our children. That's the key to it. It isn't meant to open the doors to I mean, this has been ongoing. We have cases like this, and I'm sure that Linda would testify to that. But we've had cases like this, and unfortunately, it's not a public issue. These are cases. All of our cases are confidential. It never hits the media unless it's something that deals with abuse or neglect. Because, you know, now we have parents that are been pinpointed, but when it deals with a child and it deals with issues where they're in the hospital and they properly relinquish the child to the hospital, those things never hit the media. It is confidential. It is matters that will never, the public's eyes will never see. We can give statistics and numbers, but we wouldn't give facts, and we don't discuss cases. And so that's pretty much my testimony. I'll be here for any questions if you have any questions. And of course, I'm open to discuss any other areas of this type of legislation.
Thank you to our Deputy Attorney General, Carol Hinkle Sanchez. And I also want to just recognize Senator Luis Borjamuña, who's also joined us this morning. And we can continue with the Administrator of CPS, Ms. Linda Rodriguez. Ma'am.
Good morning, Senators. Senator Cruz, Castro, Terlahi, Biscoe Lee, Mary Camacho, and Senator Muñoz. My name is Linda Rodriguez, and I'm the Administrator for the Bureau of Social Services Administration. I apologize that my director could not be present today, but he did submit a written testimony and supporting bill number 322-34. As far as the Bureau is concerned, we also support this bill. As Ms. Sanchez said, it's not really for the mother that's going to be relinquishing the child up to CPS or for adoption, but it's mainly for the protection of the child. It is true, as the gentleman said earlier this morning, that there haven't been too many cases, but just one case alone is just too many. We all recently heard in the news about the baby that was abandoned, and there was another child maybe several years ago that was abandoned, and in a park, unattended. We would like to proceed with making sure that these children are in permanent homes, because it's always better for a child to be in a permanent home, adopted with parents that love and support them, and that is only going to help these children become better citizens and have better lives in the future. Children that have been in these situations, at least I know one particular case where that child was adopted. That child is thriving in that environment and is doing very well with foster parents that actually did adopt them. So that's one of the reasons why I feel that we should support this bill. We have over 215 children right now in foster care. And putting children in foster care is traumatizing for children. In addition to that, some children develop serious emotional problems, or they just can't adjust to the abuse that they had. So placements break down, and we're always challenged to try and find new homes for these children. Multiple placements is not good for children. We've got so much scientific evidence that supports this, but this bill will help expedite the adoption process. Children will not have to be placed from home to home to home. They'll be in a permanent home where parents really want them, will take really good care of them. And this is not to demoralize the birth parents. Actually, birth parents is probably doing a very positive thing for the child, because they realize they're in a situation where they can't take care of this child, and they want the child to give a better, have a better lifestyle. And it's true that Ms. Sanchez said, we do have some parents that have already made the decision to give their children up for adoption, and once they are born at the hospital, we do intervene and put that child through the adoption process. But that's also a lengthy process, because we need to find out who the biological father is. We need to do it the right way so that parents that do adopt these children can have them permanently. The only thing I want to say else about that is that we do fully support this bill, and I think it's an excellent, not maybe excellent, but I think it will really help not only these children, but other children as well in Guam, to protect them. And I just think if there's an opportunity for a child to be in a better home, that we should try and place that child up for adoption. Thank you.
Thank you so much, Ms. Rodriguez. And then we also are in receipt of written testimony from the director, Leo Cassell. And then I also have Elizabeth Ignacio signed up. I'm not sure if she wants to testify. Thank you. I have Maria Espinosa. Please join us. Thank you.
Good morning to all of you and to all the other senators here in the committee. I have written testimony here in front of me. So thank you and your committee members for giving me the opportunity to support the intent of Bill 322-34, which, quote, allows the mother to remain anonymous without fear of criminal prosecution, unquote. As I read this bill, I was glad that some questions I had in my mind early on were answered as I proceeded to read and reread the details. However, I do have a few comments I hope the committee will seriously deliberate. Number one, on page 1, line 10 uses the word parents. Since it is a woman who carries a child to term, the word should be substituted for the word mothers. And whenever else the word parents appears, such as in section 13505, page 7, line 2. So in other words, whenever we see the word parents, we should use the word mothers because we are only addressing, the bill only addresses the mothers, protecting the mother and the child. Although, number 2, although the whole bill attempts to provide anonymity for and prevent prosecution of the mother, this word exposes glaringly the right of the biological father who may want custody of his child. And as such, I would like to suggest that 13505 section and subsection C should include a second waiver to include the rights of the father to pursue custody, and that the word paternal should be used whenever applicable. I would also like to suggest that the father be given 1 month to demand custody of his child, especially wherein he has been off island for months, being deployed in the military or attending an educational institution. Really, bottom line is we may not assume that every case is the same where the woman feels threatened by the biological father. We should always balance it off with the rights of the paternal father. You know, given that maybe you might all want, that there might be an investigation on this, but we cannot assume that each case is equal. And the last point here, on page 2, lines 6 and 7, I recommend that the motto be eliminated from the bill. It is one thing to use the phrase to teach personnel about being non-judgmental as they interact with these troubled women, but it is another thing to include the motto formally into law. It is shameful for a man and woman to perform sex and not accept responsibility for the creation of a child, and as a community, we do not want to encourage shameful behavior. Thank you for taking the time to listen to my comments.
Thank you, Ms. Espinosa, and thank you all so much for providing testimony on this bill. At this time, I'd like to open it up for my colleagues if they have any questions for the panel. Mr. Speaker.
I don't really have a question. I just wanted to thank Carol for recognizing that we did try this 6 years ago. And to CPS, I am very, very happy that this time the testimony from Public Health is in support. The bill 6 years ago was pulled because we received testimony in opposition to the bill. So I hope it goes forward because this is really imperative that we establish this as soon as possible. Thank you.
Thank you, Mr. Speaker. Madam Vice Speaker.
Thank you. I just want to thank you all for your testimony. It's been very helpful this morning. And thanks, Carol, for going over all the other states, because that's also very helpful. And I'm glad to see Fire Department and Public Health in support and on the same page, because your role in this is critical, obviously. I wanted to just make sure that it's very clear to the public what happens after the baby is surrendered. The baby will go to CPS, and then if you don't mind, Ms. Rodriguez, just to be very clear, how do you decide? I mean, you're going to put the baby into foster care, you're going to pursue an adoption. I mean, do you have a list of adoption prospective adopting parents or things like that? If you could make it clear for the public, please.
Yes. Yes, if we do exert custody over the child, we do try to put the child in a foster home, which is licensed. But of course, we have to wait for the court proceedings to make sure that all the court documents are in place and parental rights are terminated. But yes, we definitely do have a listing of foster parents. And this listing is renewed every year. I believe the last time I counted, we have about 10 to 12 foster parents that are on a waiting list. There might be more, but some of them have not renewed their applications. But definitely there are people that have been waiting for a long time to adopt children. And I know, I think it was maybe last year, the Adoption Selection Committee did meet, and we were able to place at least one child up for adoption. And it's really heartbreaking, though, when we go through the process that we can't tell the top 3 prospective adoptive parents that we couldn't select them. But, you know, there's certain parameters that we have to follow. But let me tell you, though, that the people that were able to adopt this child, they were very, very happy. And this child is going to have a very excellent life. That's all I can say. All right.
Do you, Ms. Rodriguez, agree with the 30 days old or less?
Yes. Yes, I think that is ample time. 30 days or less, yes, I believe we can do it within 30 days, yes.
Okay, well, no, they're giving mothers up to 30 days, but a child that's older than that, I'm curious why we are excluding those, maybe, Carol?
If I may, so this is meant to protect, so it's meant to really protect new parents who give birth to newborns that don't want the newborns. Prior to this, there was a mechanism that we were using through the CPS statute, but it didn't shorten time periods. It didn't do a presumptive termination of parental rights, and it didn't give it didn't make it anonymous for mothers to do this. So it would fall for those who want to give it older than 30 days. We would utilize the CPS statute and file it as a person's in need of services and follow the normal course. And I just want to answer this madam's, or chime in as to what some of her concerns. We spoke with Senator Torres when this first came up, and we did bring up due process rights of the biological father. This does not terminate his rights. We would proceed in a proceeding as we normally do in a Child Protective Act. We would proceed in a persons in need petition, and we would put notice as to this matter, and we would notice the hearing through publication of this child, so that if there is a parent who believes he's the parent, they would be able to come forward, and at that point they would be a part of the proceeding. So those notices will be we would still continue in the course we generally do, because we know there are due process rights that need to be made and kept and available for the other parent. This is just meant for the mother who gives birth and wants to relinquish the child and does not want the child and probably doesn't know who is the father, may possibly know, we don't know, but the fact is it's geared towards the mother, which is why her rights within that 48 hours, if she doesn't get the child, request for the child to be returned, her rights would be presumed terminated. So.
And then can you just repeat again, Ms. Rodriguez, for the record, the amount of children that are in foster care right now?
It should be around 215.
And do you mind telling their ages?
They range anywhere from 17 years old to 2 months.
All right, thank you very much. Thank you all for your testimony.
Thank you, Madam Vice Speaker. And I just had one question. Maybe perhaps this can be answered by our Deputy AG or the CPS Administrator. But on page 4 of the bill, subsection 13503A1 defines an authorized safe haven personnel as any medical professional licensed under Title 10, Chapter 12, to practice the healing arts. So in consideration of this section, can you just identify what professionals would be considered as an authorized safe haven personnel? Because it's my understanding that the healing arts also includes like other services, cosmetology services and the like. So if you could maybe just elaborate on that.
I would need to refer to that particular title, but I think it is mainly geared towards medical professionals that work in conjunction with those that provide emergency medical services. So I think it's limited in scope to that, or it's meant to, and I don't know if it needs to be clarified, but we can look at that particular section just to make sure. But I would need to, I didn't look at that section and I apologize, but we just need to look at it and confirm. But I think the intent is to ensure that it's placed into somebody who has who understands, some form of medical practice or performing of emergency services, medical services.
Okay, very good. Thank you for helping to clarify. Senator Castro, do you have any comments?
I just want to add to that. Sure. That section, Title 10, Chapter 12, GCA, has to do with the licensing boards and involves the licensing of medical doctors, nurses, advanced practice registered nurses. So it has to do with the those that have medical type licenses for this licensing board. And then safe haven personnel also includes the EMT licenses, which are under another statute, Title 10 of Guam Code Annotated. So it's specifically, as Attorney Sanchez mentioned, we wanted to ensure that authorized safe haven personnel were people who had some medical credentials or EMT credentials, so that we don't have a situation, for example, where somebody pulls into a hospital and hands a baby over to a guard, or someone that might be tending to custodial services, or, we want to make sure that someone who's equipped to receive a baby that may need a medical services is that person who receives. So that was the intent of that, identifying who authorized safe haven personnel are.
Thank you, Senator. Senator Muña, do you have any comments?
Thank you so much. I want to thank the panel for your testimony and helping us to understand even some of the statistics. So that was one of my questions is what are the statistics of the children in foster care we have now? Ms. Rodriguez said that there's like 250 children in foster care at the moment?
Yes, that's correct.
Do you have a waiting list for maybe foster parents is there a lack of foster parenting?
Is there a lack of foster parents?
On Guam.
Yes, there is a lack of foster parents. It seems like we're still challenged every week to find foster homes. Even our Ollie shelter is short of staff, so they are not always able to take children because, they need to meet the staff-child ratio. But we're working really closely with them to try and place children there also.
I'm in full support of this bill, but I wonder too if maybe it may cause a little bit more strain on your staff because already you don't have a whole lot of staff members in your department. And Ms. Sanchez said that it doesn't happen all the time, but it does happen. So I'm wondering if this would maybe put a little bit more strain on your duties, because it really won't create more personnel for you. It'll just create more duties. Will this be something that CPS can handle?
It's actually our job to do these things, to make sure that children are safe. So perhaps it would put a little strain on us, but it is our responsibility to make sure that all kids on Guam are safe and are in a safe home. So,
in that note, I do want to congratulate and thank you all for all the hard work. I know that we had one very highly media-covered case, and I think you did such a wonderful job. So I just want to thank you and all of your staff for everything that you've done for that little child and everybody who was involved. So thank you so much, and good luck to you. Thank you.
Thank you.
Thank you, Senator Muña. I'd like to give the author of the bill an opportunity to close, but I'd also just like to thank you all for coming and for providing testimony to the committee. We are very much in support of this bill, and I will work with my committee members to ensure that this gets reported out as soon as possible. But some of the things that I just wanted to highlight from Ms. Rodriguez's testimony and our attorney, our deputy AG, is just really what you had said, ma'am. One case is one too many, and I wholeheartedly agree with that statement, and I think that this is just an effort for us as a community and as stakeholders to really prioritize the protection of our children and to make sure that they're given the best possible outcomes. So we thank you for all the work that you all do every day to ensure that that's the case, and I'm handing it over to Senator Torres for her final remarks. Thank you.
I want to express my gratitude to all of you who have come to testify, and also for your work ahead of this bill in meeting with me and giving me your invaluable insight into the realities of what your respective agencies face and the true and pressing needs to have a safe haven bill on Guam. And one of the interesting questions that a media person posed to me is, are we behind the eighth ball? Why now? Why haven't we done it when 50 other states have? And we acknowledge that in our community, we have a very close-knit community, and we tend to care for our families. But we also now understand that there are additional stressors and circumstances that are out of the norm of what we consider Guam, and that we have to be flexible and adapt to situations. But I also want to hone in on the fact that what this bill does, all your good efforts are recognized, and we understand the challenges that you have with placing children. But the advantage I see to this more than a strain is that this will help Child Protective Services, the AG's office, to facilitate and expedite adoptions of babies who are, in the minds of many community members, the more desired of adoptive children. The brand new infants. So this is one way that we can help those kids who would otherwise be in dire situations to have a fresh start in life and not have to subject themselves to being placed in multiple foster homes. So there is a humane and reasonable way to deal with this situation. I believe you've helped me to come to understand that this is a good and viable solution. So Sedus Masi, and I also want to acknowledge that that when we were looking at the time to implement, that everyone I spoke with agreed that immediate is appropriate, and that you're well equipped within your protocols now to execute a safe haven program on Guam. So Sedus Masi, and again, thank you also for educating me and helping me to include all the details that we would have to anticipate with this Safe Haven Act. Thank you.
Thank you, Senator. Thank you all. You're excused. And the committee will continue to accept testimony for this bill and all the bills on our agenda today for the next 10 days. Again, you can email them to Senator Biscoe Lee at guamlegislature.org and or drop them off to our office, 163 Chalan Sanso Papa here in Hagåtña. Next up on our agenda, we'll move to bill number 276. introduced by Senator Dennis G. Rodriguez Jr., Senator Tommy Morrison, and Senator William M. Castro. This is an act to add a new section 50120 to Chapter 50, the Guam Economic Development and Commerce Authority, 12 GCA autonomous agencies relative to directing the Guam Economic Development Authority in collaboration with the Office of Technology to develop and publish a request for information relative to how an interested contractor, internet service provider, or operator would design a municipal Wi-Fi service to provide internet access to the entire island of Guam. And we have several members of the community signed up to testify for this bill. But before I do that, Senator Rodriguez is unable to join us this morning, but I do have a statement that he's written out, and I'll read it into the record. Dear Senator Lee, the internet is an essential utility of the 21st century. More and more of our lives and systems are reliant upon access to the internet, and this trend will not stop. Having internet access brings communities together. It improves learning outcomes for students and drives economic growth. The world will continue to improve and develop more Internet of Things, which will drive cost reductions and improve our lives. The advantages and impacts of a connected world are only limited by our imagination. Unfortunately, the people of Guam have only limited direct benefit of this infrastructure to use on our island. Many still lack access to the internet, and we lag behind in joining and benefiting from many advantages a connected island would bring. In early 2000, technology experts began discussing the concept of municipal Wi-Fi, a program that would enhance access to all the people in a community. Research shows many attempts, some successful and some failures, were made on providing free or low-cost access to entire cities. In the decade that passed, a great deal of refinement was made on those early attempts using the lessons learned in the startup communities. The time is right to take advantage of the experience gained from those early attempts and to get input from companies on what models for providing free public Wi-Fi might be successful in our community. The purpose of this bill is to learn how companies would provide this service at low or no cost to our island and enter into a carefully crafted public-private partnership that would blanket our entire island with internet access. The goal is to use information gathered to develop a comprehensive approach to expanding internet access to all our people and to build island-wide infrastructure to take advantage of current and future Internet of Things. Signed, Dennis G. Rodriguez Jr. And at this time, I'd like to invite some individuals who've signed up to testify. Mr. James Passion from Wi-Fi on Guam, Eleanor Lujan Tovis with Docomo Pacific, also Sean Miles, Judy Rosario, Dan Tidinko with GTA. If you are interested in providing oral testimony at this time, please join us. And we'll begin with Mr. Passion.
Thank you so much. Madam Chair, Senator Lee, Vice Speaker Terlahi, Senator Castro, Senator Torres, and Senator Muñoz. Thank you for giving me the opportunity to testify in favor of Bill 276-34, which is an act to seek input from interested parties in the form of an RFI, showing how designing a municipal Wi-Fi would be possible. My name is James Pashon, and in 2012, I created the website wifiionguam.com. And Wi-Fi on Guam offers for free to everyone the most comprehensive listing of public Wi-Fi venues on our island. What started as a random Sunday project many years ago has now grown to be a pivotal resource to many Guam residents and tourists alike. With an average of 1,400 page views a month, Wi-Fi in Guam has fostered quite an underground following. Visitors of the website include high school students, college students, self-employed, even remote workers, colleagues on lunch break. And what's more, prominent members have even gone so much to donate to the project itself. These have helped fuel the project since it's only been funded by personal funds since its inception. A search on Google for Guam Wi-Fi shows Wi-Fi on Guam as #1. And really, I'm just humbled by the stats and the milestones, but really this is just a testament to the demand of public Wi-Fi on our island. I come before you this morning to fully support this bill. What I find great about it is it presents the ambition and the possibility of Wi-Fi, but not in a very jarring way. It's a baby step forward, if you will. It's true that change, especially big change, is not easy to stomach at first, but it's something that is welcomed with a sigh of relief once that change is in place and the comforts are being realized. Said another way, it's like a major road repair. While for weeks on end, it frustrates all of us. When it's finished and operational, that road, we internally shout praises and gratitude for having it completed. So rather than a bill that mandates its immediate implementation, what Bill 276-34 does, it begins the dialogue of exploring how municipal Wi-Fi would be possible. That being said, should this bill be signed into law, I pledge to be a part of the dialogue, both in an individual capacity and as the president for the Junior Chamber International of Guam. I pledge to offer assistance to those that will submit an RFI, even submit an RFI myself if need be. In my capacity as president of JCI Guam, I pledge to give way to projects dedicated to alleviating the burdens and the concerns over the implications behind its implementation. Express bright opportunities island-wide Wi-Fi can bring to all industries and aspects of life on Guam. Free Wi-Fi can save lives. We can better respond to stranded hikers or swimmers, for example. Free island Wi-Fi, in the eyes of tourism, can become Guam's most unique selling point. We have more and more visitors to Guam relying on bloggers and even being bloggers themselves, talking about the island. Members of our homeless community can be given a mobile phone in a way that sort of testifies how much they need their Wi-Fi. More homeless people today have mobile phones, quite surprisingly. And it's gonna propel Guam to do what I initiate as Guam 2.0 in all aspects of government, in trade, and innovation. And this just barely scratches the surface. And I bring up Wi-Fi on Guam because, in a way, we've already begun the implementation of a primitive form of municipal Wi-Fi. Imagine anyone at any time, wherever they are, can go to wifiongguam.com right now, find the venue they're in, and be connected to the internet in a matter of seconds. Now imagine using the website over a period of time and connecting to each venue listed on that website. Because of technology today, your mobile phone and your mobile device, what have you, your tablet, can seamlessly switch from Wi-Fi network to Wi-Fi network. You'll barely even notice it. And so it's been my experience since I've connected to majority of these Wi-Fi venues that I hardly need to use data, because at any coffee shop, my mobile phone and my computer recognize the Wi-Fi network and connect automatically. And just like that, Wi-Fi is accessible a lot more prevalently. So in a sense, it's already begun, and I feel this bill just helps to propel this forward in a way that is more tangible to everyone else. And I feel that's something that I would like to have happen with this bill. So I support it, and I thank you for your time to hear my testimony. Thanks so much.
Thank you, Mr. Pichon. Any of my colleagues have any questions for Vice Speaker? Thank you very much for your testimony. And again, we'll be receiving testimony on this bill for the next 10 days via email, or you can hand deliver it to our office. We want to thank you very much for coming in and for providing your testimony, and also for the service that you provide to our community. One of the things that I had a concern about with this bill, and maybe will just help to tighten up the language a little bit, is to ensure that any issues with cybersecurity and communicating personal information on a municipal Wi-Fi service would be protected. Those kinds of information would be protected. And so that's one of the things that I wanted to be able to discuss with perhaps the Office of Technology as we move forward with this bill. And so I will be getting in contact with the author and also with OTEC to try to just get some of those questions answered. But I want to thank you again for coming in and for taking the time to provide us with your testimony. Sujasmasi. Mr. Charico?
Thank you,
Thank you.
Madam Chairwoman. Vice Speaker Talai, Senator Castro, Senator Torres, Senator Muñoz. I didn't really come here to testify this morning. I came here to primarily observe and listen to anybody who's testifying or hear any feedback from the authors of the legislation. There are some corrections that I would make concerning a number of the provisions cited here with regards to the goal and intent here. Specifically, first, the island is neither unserved or underserved, as suggested by the author. Each and every broadband communications provider on island has to provide annual reports to the Federal Communications Commission. As of the last report I saw, even back in 2010, 98% of the island had 10 megabits or better already on for service availability for broadband and internet capacity. That's probably been exceeded from 2010. So most everybody on island who has access to a device has the capability to have broadband and Wi-Fi connectivity. There's a number of infrastructure build-outs that have been taking place, whether it be from us at GTA or our fine friends over there at Delcomo, who have had several wireless access points erected throughout the island on all of the towers of the networks, et cetera, as well as what the previous witness had indicated. Anybody can go into almost any facility on the island right now or enterprise and have Wi-Fi connectivity with his or her device. Concerning Wi-Fi for the community, GTA, as part of our asset purchase agreement back in 2005 when the legislature approved the privatization of the Guam Telephone Authority back then, one of our obligations under the asset purchase agreement was to ensure that we provide anchored community access. So in that regard, we've been giving internet and other services that GTA provides to almost all of the mayoral offices and community centers and senior citizen centers since then. We had strived a few years back to give some free Wi-Fi and internet over to Simon Sanchez, which has always been a topic of discussion in the legislature the past few years. Unfortunately, our efforts were rebuffed by the Department of Education, and we said, okay, fine. And we ended up giving it to the parochial schools. We ended up giving it to Santa Barbara, St. Francis, and St. Anthony. But we strive to do a number of things to ensure that there's sufficient Wi-Fi connectivity for the community and that there's ample and robust services that's available to them. In a couple of weeks, we'll be having a hearing before Senator Atta's committee in conjunction with the PD Municipal Planning Council and the Office of the Mayor concerning the cable landing station that GTA has down in PD. So we're making additional strides with regards to that particular facility and the infrastructure there. And there's some very, very exciting things that are going to be happening for the village and community of PD. And that'll probably be unveiled to everybody at that particular point in time. But I understand what the authors are striving for, but I just want to make some clarification some suggestions for clarification as they strive to develop the legislation and proceed any further. Senator Lee's talk, you've broached a very particular and important topic there concerning security, cybersecurity. These are questions for the legislature to have to ensure that GITA and whoever else develops it, the legislation as it wends its way through the process, that maintenance of the Wi-Fi network out there, if it's a public Wi-Fi network, liabilities and security, those are all provisions that have to be contained within there. We've all had to adhere to a network security agreement with a national security agreement, a national security agreement for network security with the federal government. There's a whole host of security entities called Team Telecom, which is the whole alphabet soup of security agencies throughout the United States, as well as now they do, DOCOMO has to, and everybody else with the exception of GTA, since we're the only American-owned telecommunications company on island, but the others have to contend with a particular group that's not really talked about. It's called CFIUS, the Committee on Foreign Investment in the United States, which is run out of the White House and also the Treasury and Commerce departments that have to make sure that there are strict network and operational security measures in place. So these are things for the Office of Technology, GITA, and whatever other public entity is going to be involved in the development of this legislation going forward.
Thank you, Mr. Taidenko. Senator Castro.
Thank you for the clarification. I think I can acknowledge the penetration rate, especially with respect to coverage. I can't speak for the author, but at least for my contribution to the discussion, and perhaps the other telecom partners in the room can sit down with me again and pick up where we left off here, is more along the lines of low to no cost access, at least for students and for the sake of educational purposes. We know that our public libraries have limited hours and days that they're open, and we know that our public schools are limited in terms of students having access as well. So now that we're able to clarify that for the record, we can elevate the discussion, and at least the team could sit down with you and others to say, to explore ways we can subsidize or find other ways to give children access to the internet for educational purposes from the comfort of their living room. I don't think anybody's going to debate that we have tremendous penetration. The issue is low to no cost access to data, So thank you, but I appreciate that, Mr. Taidenko.
Well, all the schools, Senator, are eligible to participate in the E-rate program, whether it's the public or the private schools. That's just something that the Department of Education would have to develop in their particular specs. And this is something of a policy discussion with the legislature. If you guys want to migrate towards doing iPads and books, the charter school up in Ukadu is already doing it without having to put a significant outlay for textbooks, per se. So,
Madam Vice Speaker.
Thank you. Thank you for your testimony, Mr. Taidenko. I'm glad that you clarified some of those things because I've heard this discussion over several years, and it seems to me like the government of Guam should be benefiting, and that we should have access in the villages. I know that there was legislation regarding access in the mayor's offices, and then there was the libraries have always come in here and talked about access in the libraries, and And then recently we spoke with UOG, who has hooked up into a very high-speed research network. I guess it's a very exclusive and very good thing. I'm trying to think of the right word, but a very prestigious thing that they've been hooked into to be the regional hub for this region. And but when we talked with them, it was my hope, and I thought that they had committed to using their resources to extend this into DOE, which is in almost every village, which would in turn hopefully extend, you know, some of this access into the villages for students. And at least for those purposes, for students, I agree we should pursue any type of access for all hours. And then we've also heard discussion in the legislature regarding the Chamorro Trust leases for some of these cable landings. And I think we should review all of those and make sure that the government of Guam is getting its best value for those things. But thank you. I'm looking forward to the PD, what's happening down in PD, and but I think we should review all of them. So thank you, Madam Chair.
Just a clarification, Senator, with regards to landing stations, at least in our experience with GTA on the terrestrial side, again, you guys had approved under the asset purchase agreement back in 2005 that facility up there, and that's so you guys have been involved in the process concerning the legislation that's coming up in a couple of weeks with PD again. That's why it's a piece of legislation for continued legislative scrutiny and review. So.
Thank you, Mr. Taidenko. And if there are no other members of the community that would like to testify, again, we will be receiving any written testimonies via email, or they can be hand-delivered to our office. And so with that, we will consider Bill 276-34 publicly heard. And last on our agenda this morning is Bill 328-34. And again, Senator Rodriguez is unable to join us this morning, so I'll just read his statement into the record. Senator Lee, Guam and Micronesia provide unique aspects that may be of interest to pharmaceutical research, to the pharmaceutical research community. Our location, weather, and government structure provide certain advantages that are found nowhere else in the world. Micronesia also has unique flora and fauna used for centuries in treating ailments of local indigenous persons, and the use of these treatments is untapped by current modern scientific research, and thus may reveal active pharmaceutical ingredients, API, that would have large addressable markets internationally, and in which Guam could retain a proprietary interest. Although not an indigenous plant, cannabis has been propagated in Guam and Micronesia for years. There is undeniable interest in the global community in the study of non-psychoactive cannabinoid pharmaceuticals, or NPCPs. The use of NPCPs in treating ailments is becoming more and more accepted, yet the research on cannabis was restricted in the United States for many years. Guam's geographical and political position as a remote, self-governing U.S. territory may be the perfect solution for large laboratory and pharmaceutical companies to perform such desired research. The purpose of this RFI is to seek information on how interested pharmaceutical research companies would partner with government entities to form a public-private partnership to develop a laboratory and/or pharmaceutical research facility. We don't have any members of the community that are slated to testify on this bill, but again, we will be receiving testimony for the next 10 days. Do any of my colleagues have any questions or comments with regard to this bill? If not, we will also consider Bill 328-34 as being publicly heard. And with that, Sizus Maasi Torres Hamzu, the Committee on Innovation and Economic, Workforce, and Youth Development has duly heard Bills 322, 328, and 276, Written testimonies may continue to be submitted to our office by emailing Senator Biscoe Lee at guamlegislature.org or by hand delivering it to us at 163 Chalan Santo Papa here in Hagåtña. Those who wish to submit testimonies will have 10 days to submit it. This hearing is now adjourned at 11:18 a.m. Siduos Masi.